even a sick person has a right to information. That was not taken into account in 1959. And we see itself repeating itself in 1989. It also failed to embrace the World Health Organization model of mental health treatment, which recommends an optimum mix of mental health services, such as counseling. You've heard that from our previous presenters. That is very key. Psychotherapy, aftercare, and rehabilitation services beside pharmacological intervention. These were all not addressed in that act, and yet it was a mental health act. It did little to uphold community mental health services as the primary care level, and made no distinction between mental illness and mental disability. Allow me just to share a short story on that. Just 2 weeks ago, I was in court with my legal assistant who has accompanied me today in a matter that we are having in court. And the advocate on the other side sought an adjournment not to proceed on the reason that he needed to substitute the witness statement and the affidavit of his client. He needed to substitute with a statement of the son. And he said, I have filed in the lands registry what is known as a power of attorney, and the son will be the attorney of my client. And the first question the judge asked, why have you filed a power of attorney to substitute? And he said, because my client is sick. My client does not have the capacity to represent himself anymore. That's why I need to substitute this client with someone who can represent him. But when you go to the Mental Health Act that was in existence that time, let's even talk about the 1989. How do you do that if someone doesn't have the capacity? And is it mental illness or is it mental disability? The Mental Health Act at that point required you to file an application to appoint a guardian, because your mental capacity right now is not right and you're not able to make the decisions that you would have made if you're okay. And you didn't need to do a power of attorney for that. A power of attorney is for other issues and does not relate to issues of mental health. And the judge was insisting, no, you don't need to file a power of attorney. Go back to the Mental Health Act and look at the provisions. But because of that lack of knowing, the advocate stated, client wangu si mwenda wazimu. You see there, sometimes we say that, yes, we need to go out there and sensitize we go to the grassroots, but it also starts with us. Some of us, even me as I stand here, there may be other things that I am not aware of, and that's why we come here together, to be able to appreciate the things that we don't understand. So even in that particular act, it was very difficult to understand what is mental illness and what is mental disability. And that is why, even as advocates, I stand before the court and I can still tell the court, client wangu si mwenda wazimu, and that's not what was at issue. After the 1989, which was still existence then, and because of the issues that were brought by COVID-19, there was the Kenya Mental Health Policy, which provided for a framework on intervention of securing mental health systems. Why was this put in place? The government declared mental health because of calls and cries from various stakeholders, because of the bill that was proposed by our senator, and declared mental health as a state of emergency that needed to be dealt with. And that is why the Kenya Mental Health Policy came into existence, which is committed to pursue policy measures and strategies for achieving optimal health status and capacity of each individual. Apart from that, there was also the 2019 Task Force of Mental Health, which came into place in December 2019. Its role was to study the status of mental health in Kenya, identify related determinants, identify contributing risk factors, and recommend transformative solutions to reform mental health system. All these were being done, and all this was a journey to ensure that before the enactment of this act that we are talking about right now, everything has been addressed and everything has been put in place so that the enactment and the implementation can be effectively done. Then in July 2020, the task force submitted its recommendation. And that's the declaration that I was talking about. Mental illness was declared a national emergency. It became a priority as a public health and socioeconomic agenda. There was need to establish a mental health commission to advise and coordinate continuously and monitor the status of mental health and the report on the annual National Happiness Index. And lastly, before the bill, there was the Mental Health Action Plan. This was developed to provide the framework to implement the recommendation from the mental health policy and the task force report that we have seen. The action plan had the objective of improving mental health management in Kenya. And this action plan is supposed to take us up to 2025 to ensure that all the plans or all the actions that have been addressed there, that have been stated there, are actually addressed by the time we reach 2025. It provides the framework for the country's mental health transformational journey over the next 5 years. It also aims to provide strengthening mental health systems, implementing programs meant to promote mental health, and ensuring access to comprehensive, integrated, and high-quality mental health service to all levels. Through the plan, as I stated earlier, it was sponsored by the nominated Senator, Sylvia Kasanga, and was passed in June through a parliamentary process. On June 21st, the Mental Health Amendment Act was signed into law. And as we sit now today, we need to know and we need to appreciate this is already a law that needs to be implemented. We all have the responsibility, all stakeholders, to come together, sensitize the public, sensitize everyone else, the county, the central government. It is our responsibility. Private individuals, that's our responsibility. If we don't sensitize, no one will know that we already have an act. Everyone will be thinking we still have a bill that is yes passed into law. This particular act, at that point the bill, amends the Mental Health Act of 2019 that I was talking about. So until June, 21st June this year, the law that was existing was the Mental Health Act of 2021, of 2019. This act aligns the country's mental health laws in light of the key milestones brought about by the Constitution, that is under Article 43, 23, and 21, and other attendant laws like the Health Act 2017. What is the purpose of the act? As we go out there to sensitize our friends, our families, our members, our clients, and Kenyans in general, to promote the mental health and well-being of all persons, to coordinate the prevention of mental illness, access to mental health care, treatment and rehabilitation services of persons with mental illness, to reduce the... I will share all this with you. Allow me just to go to the key provisions of the act. Enumeration of rights of persons with mental illness. That is a major key provision in the act. If you just give me a minute. When we talk about enumeration of rights of person with mental illness, I talked about survivors of sexual violence. The act has provided for this, that survivors of sexual violence are entitled to access affordable mental health in different health facilities. The act enumerates the right of persons with mental illness, including the right to protection from sexual exploitation. The act recognizes post and postpartum depression and person with mental impairment due to dependence on substance, which is something that is really common in the coast, and alcohol abuse, and mentally ill persons, by providing that a person with mental illness means a person who has been found to be suffering under the Mental Act, and includes a person suffering from maternal mental illness and a person diagnosed with mental impairment due to alcohol or substance abuse. This is something that was not in the Mental Act of 2019, but is now in the Mental Act of 2022. The Act makes provisions for mental health insurance, that is NHIF, in both comprehensive public health facilities and non-comprehensive schemes. Those are private hospitals. The Act gives priority to community health and outpatient primary mental health care and treatment, as opposed to institutionalization of the person with mental illness. It makes reference to health units as opposed to hospitals. It makes provisions for persons who present themselves voluntarily in a mental health facility or unit for treatment or admission, and provides the procedure that you're supposed to follow, a simplified procedure. It provides also for consent to appropriate form of treatment and participation of person. A mentally ill person can be taken into custody if the chief